Hello, my name is Suzanne Natbony, and I'm a licensed California attorney practicing out of Los Angeles. I practice mostly business law, so I inevitably deal with employment law issues.
And I'm Joseph Hekmat, an attorney licensed in California and New York who represents employees. In this video, we're going to discuss some issues to consider if you've been fired from your job.
Losing your job is one of the most stressful things that can happen to anyone. Absent a contract, most types of employment in California are considered at will, meaning that you're working at your employer's will and your employer can fire you for almost any reason or no reason at all, unless it's an illegal reason. So, what are some unlawful reasons to fire an employee?
Let's start with discrimination. According to federal law, an employer can't fire you or discriminate against you based on your race, color, religion, sex, or national origin. Different states include other categories as well, such as disability or medical condition, marital status, or sexual orientation. If you have a medical condition or disability, for example, your employer may be required to accommodate your situation so that you can continue to work. Next, sexual harassment from a coworker or supervisor is also illegal. It's generally experienced in a couple of ways. In one way, quid pro quo situation, a supervisor may make you do something sexual or uncomfortable, like forcing you to go on a date, in exchange for a promotion. Or you may find you're working in a hostile work environment where you are simply subjected to verbal or physical treatment so frequent or egregious, an ordinary person would find working there intolerable.
A third area is called whistleblowing. It is illegal to be terminated for reporting your employer's illegal acts, such as reporting unsafe working conditions, labor code violations, or government theft. Similarly, it is illegal to be retaliated against for refusing to break the law or engaging in a protected activity, such as filing a charge with the Equal Employment Opportunity Commission, seeking accommodation for a disability or pregnancy, filing a workers' compensation claim, or taking family or medical leave. Your employer cannot require you to break the law as a term of your employment. For example, if you're a bookkeeper who refuses to falsify tax records, or you're a physician who refuses to incorrectly chart medical information, you might have a claim.
Now, of course, it's important to remember that these are only several examples, and there are a host of other illegal reasons considered to be in violation of public policy. Every case is different, so remember it's best to speak to a lawyer and get insight on your potential case. An experienced employment lawyer can help you navigate your rights and guide you through your options when an employer has mistreated you at work. If you've been unlawfully discharged, you may be able to recover money damages, such as lost earnings, pain and suffering for emotional hardship, and you may even be able to get your job back.
If you do have a legal claim against your employer, you may find a lawyer who won't charge you unless she gets you a monetary settlement or favorable verdict. Contingency fee representation can mean that if the lawyer doesn't recover any money for you, then you don't have to pay anything. Some employment lawyers might work hourly or contingency fee, depending on the likelihood of success of your claim or other factors. For more information or to speak to an attorney, please fill out the free employment law intake form to the right of this video and return it to the email address below. Thank you.